take the responsibility of surety on behalf of the bank in case of default by the subsidiary company. So there are three parties involved in this transaction. Number one, principal debtor is a person in respect of whom default guarantee is given. And there is a creditor, person to whom guarantee is given. In our example, it is a subsidiary company. And the surety is a parent entity who has given the guarantee. Now, as far as the contract is concerned, there should be a consideration. So anything done or any promise made for the benefit of the principal debtor may be a sufficient consideration to the surety for giving the guarantee. So here we are treating it as a consideration. Now I would like to take a couple of examples which we will be referring to in our deliberation. Point number one, the subsidiary company's director is giving a personal guarantee on behalf of the bank for taking the loan. There is another instances where the parent entity, parent private limited, has given guarantee to the subsidiary private limited on behalf of the bank. So these are the two examples we will be taking. As we deliberate further, I will let you know why this distinction has been done. This is mainly done with the circular, master circular issued by the RBI. Now the concept of intercorporate guarantee. So in simple terms, a corporate guarantor, here the example what we have taken is a parent entity, which agrees to take the responsibility for debtor's obligation, such as repaying a debt, that is on behalf of the subsidiary entity. Now, under the Companies Act, there are restrictions with regard to the guarantee. So Section 85 debars a company from providing loan or guarantee and security in favor of its directors or any other persons in whom the director is interested in. But however, there are few exceptions where the holding company can give the guarantee to its wholly owned subsidiary company or even security or loans. So this is acting as a exceptions under the company law. Now under the income tax, though it has got no relevance, but only from the perspective whether it can be treated as a service, I have drawn the inferences from the income tax law. Now in the case of Mumbai Dyeing and Manufacturing Company Limited versus DCIT, Tribunal has held that corporate guarantee was provided by the parent company for the overall benefit of the business of the group and therefore ultimately benefiting the parent company itself. This is very important observation, that it is ultimately benefiting the parent company itself. Now, having regard to the direct and indirect commercial interest of the company, corporate guarantee is given with a view to safeguard and to further business interest. That is the business interest of the parent entity itself or the entity which is giving the corporate guarantee. Now, Tribunal has held that corporate guarantee is a mutual beneficial activity. So they are not looking from the perspective of the services. They are treating that it is a mutual benefit which is being done to the same entity itself because it is going to increase the value of the shareholders. Now, there is another case law, that is in the case of Micro Inc. versus Assistant Commissioner of Income Tax, wherein it has been held that guarantees were prima facie in the nature of the shareholders' activity. The other observations made in this case is that the purpose of guarantee is to provide or compensate for a lack or core strength of raising the finances from the bank. So obviously, when the corporate guarantee will come into picture is that when subsidiary doesn't have a core strength of raising its finances on its own, then in that case, the parent entity or the related company will come into picture to give the financial strength so that bank can lend loans. Even going by the OECD guidelines also, it is not really possible to hold corporate guarantee issued by the taxpayer wherein the nature or provision of service and not a shareholder's activity which is mutually exclusive in nature. So therefore, they are contending that it is not a service provided to the subsidiary entity. Now, with these premises, we now go on to the service tax provisions. In the case of Sterlite Industries India Limited versus Commissioner of GST and CSTAT held that. Now, they have tried to distinguish bank guarantee when compared to corporate guarantee. Why I have brought in this aspect is that in subsequent cases, they tried to take the open market value of the bank guarantee, whatever the percentage which bank is going to charge, that as a basis for the purpose of valuation. Now, the bank guarantee is given by a bank on behalf of the customer to the beneficiary bank, guaranteeing the payment in case of default by the customer. So the claim will be there only in case of default. Now, these bank guarantees are issued by the bank on a regular basis as part of their business of banking. So when it comes to the corporate guarantee, it certainly has got a distinction. So here guarantee is given by the corporate to cover their own exposure or exposure of some other related party to their bank. So it is within the entity itself. The second thing is that corporate guarantee that was entered into by the appellant is only for limited purpose of securing loan to its subsidiary. It is not carried out as a normal business activity when compared to the banks. Now, under the erstwhile service tax law, consideration is very important. So service tax was only applicable on any activities where the person was performing any activity for another person for a consideration. So there are two aspects that has to be looked into. One, there should be a person who is performing the activity, and another one should be for a consideration. When these two conditions are satisfied, then service tax is leviable to a transactions. So even in case of an associated enterprise, a book entry was required to make the said activity taxable. So in case if there is a transactions which is not been accounted in the books, then it will not be subjected to service tax. So accordingly, in the absence of any consideration charged or book entry by the group and company for extending such corporate guarantee, service tax was not applicable on the said transaction. So to conclude on this particular under service tax is that one is consideration is very relevant. Now, in the case of Edelweiss's Financial Services Private Limited, CSTAT has observed as follows. One is criticality of the considerations, as we saw in the previous slide. So for determination of service as defined under section 65B44 of the Finance Act 1994, after introduction of the negative list, regime of taxation has been rightly construed by the adjudicating authority. Now, any activity must, for the purpose of taxability under Finance Act 1994, not only in respect of another, reveal a provider, but also the flow of consideration for rendering of the service. This is very important aspect, which we were deliberating on the two elements. Now, it is clear that there is no consideration insofar as corporate guarantee issued by the respondent on behalf of their subsidiary company is concerned, and hence there is no service tax levy. Further, the Supreme Court in the same case also held that assessee has not received any consideration while providing corporate guarantee to its group companies. Further observed that the revenue has not made any effort to assail the above findings or to demonstrate that issuance of corporate guarantee to group companies without consideration would be a taxable service. So in these circumstances, in view of such conclusive findings of both forums, we see no reason to admit this case. So it has been passed in favor of the assessee. Now the question arises whether the precedent under the service tax can be used under the GST law. The answer is no. We will see the reasons why we cannot use the precedents under the service tax. law. Point number one, the levy under GST is on the supply of goods or services or both. Now, supply has been defined very exhaustively, which includes all forms of supply such as sale, exchange, barter, etc. by a person for a consideration in the course or furtherance of the business. Further, supply of goods or services between related persons in the course or furtherance of business is taxable even if there is no consideration. So therefore, we are covered under these provisions where corporate guarantee would be subjected to tax even if there is no consideration. The council has also provided that the central government or state government, where the services is provided to any business entity, including PSU, by way of guaranteeing the loan taken from financial institution against consideration. This is very important. So as far as central government and state government is concerned, they have mentioned it against consideration. It shall be taxable. Further, in case of private entities, the board is of the view that intercorporate guarantees would amount to a service. Further, we move on to Schedule 3, where the activities or transaction which shall neither be treated as a supply of goods nor supply of services, which includes actionable claim. Now, can this be treated as an actionable claim? Now, we refer to the term actionable claim, which has been defined to mean claim of any debt. But however, this point has to be taken into consideration. Other than debt secured by mortgage of immovable property or by hypothecations or pledge of movable property or to any beneficial interest in movable property, not in the possession, either actual or constructive, of the claimant, which the civil court recognizes as affording ground for relief, whether such debt or beneficial interest be existent, accruing, conditional, or contingent. So what does it mean here is that, so actionable claim means a claim of any debt which is not covered by any movable or immovable property. So when we see this definition in the light of the corporate guarantee is not secured by any hypothecation or pledge of movable property or any beneficial interest in the movable property. So therefore, we can say that corporate guarantee is an actionable claim. But now the question arises, this corporate guarantee will be invoked only when the surety, only when the debtor has failed to discharge the liability to the banker. So therefore, it will crystallize only at a later point in time. It cannot crystallize in the first instance. So prima facie, it would be difficult to argue that transaction of corporate guarantee would qualify as an actionable claim. Now coming to the valuations. Under GST law, we need to take into considerations, we have to value the transactions. Under the GST, the transaction is subjected to tax even without consideration. This is point number one. Now it is important to determine as to on what basis the said transactions would be taxable under GST. Now, as per Rule 27, it makes a reference to the open market value or value of supplies of like kind and quality. Here we are referring to the Mumbai High Court in the case of CIT versus Everest Kento Cylinders Limited, where they said that corporate guarantee commission, which has been valued at 0.5% of the loan amount, is lower when compared to the guarantee cost of the bank guarantee. So it was been held that the commission shall be determined by considering the commission rate charged by bank for providing the bank guarantee to the companies. However, as we have seen that bank guarantee is different when compared to corporate guarantee. So bank guarantee carries out this activity as a business vertical, separate business vertical. But however, as far as corporate guarantee is concerned, it is very difficult to get a open market value. So hence, the Honorable Mumbai High Court has rejected the said submission and held that bank guarantees are different from corporate guarantees, and the rate charged by bank cannot be substituted for the purpose of corporate guarantee. So accordingly, the open market value cannot be determined with the help of prevailing bank guarantee rates. So since both are not comparable. Further, Rule 31 provides that where the value of supply cannot be determined under Rule 27 to 30, the same shall be determined using reasonable means consistent with the principle and the general provisions of Section 15 and the provisions of this chapter. So in the light of this, we had a references to the safe harbor rules provided by CBDT. As per the safe harbor rules, the commissioner fee declared in relation to the corporate guarantee shall not be less than 1% per annum on the amount guaranteed. So therefore, we can take this as a basis for the purpose of valuation of corporate guarantee in the absence of open market value. Now coming to the circular number 199, November 2023. So I have taken only an extract of the circular which is pertaining to the internally generated services, wherein the HO is providing certain services to the branch office, for which full ITC is available to the concerned branch office. So however, HO may not be issuing a tax invoice to the concerned BO with respect to such services, because in most of the cases, there is no invoices which has been raised by the parent entity to the subsidiary company. So under these circumstances, where full ITC is available to the recipient, if HO has not issued a tax invoice to the branch office in respect of any particular service being rendered by HO to the said BO, the value of such services may be deemed to be declared as nil by HO to BO and may be deemed as an open market value in terms of second proviso to Rule 28 of CGST rules. So as we discussed with regard to the valuations, number one is we may adopt the safe harbor rule for the purpose of arriving at the valuation at 1% of the guaranteed amount. The second thing is we can refer to the circular, and where there is no consideration, we can, and the branch office is able to take full input tax credit, then in the absence of any invoices, nil rate can be adopted as a valuations. So this circular number 199 is more beneficial where full ITC is available. Otherwise, we have to go by the safe harbor rules. Now I would like to refer to the RBI Master Circular. Now this is very relevant, and I thank Venu sir for making this to be a part of this slide. The reason is that we will be able to understand why GST Council has taken a different treatment when it comes to the personal guarantee provided by the directors when compared to the government corporate guarantee provided by the parent entity. I would like to refer to the extract of the circular with regard to the worth of guarantors, payment of guarantee commission, etc. I would like to emphasize on this particular aspect which has been highlighted in red color, that is the system of obtaining guarantee should not be used by the directors and other managerial person as a source of income from the company. Further, they went on to say that the bank should verify that the directors are not charging, and also they have to take a declaration from both the company as well as director that there is no consideration involved in it. So there may, however, be an exceptional cases where payment of remuneration may be permitted. That is where assisted concerns are not doing well and the existing guarantors are no longer connected with the management, but continuance of their guarantee is considered essential because the new management guarantee is neither not available or is found inadequate. So in those cases, the RBI is carving an exception where the directors can claim it as a remuneration. Now we come to the safe harbor rule. So wherein they stated that the transaction should not be less than 1% of the amount guaranteed. So this is the valuations we can adopt, which is from the income tax. Now with this, we will see the GST 52nd GST Council recommendations. It will make sense with regard to the directors. What it says is that in case where no consideration is paid by the company to the director in any form, whether directly or indirectly, for providing personal guarantee to the bank or financial institutions on their behalf, the open market value of the said transaction or supply may be treated as zero, and no tax to be payable in respect of supply of such services. I would like to emphasize the RBI circular where it stated that the director cannot charge any commission or consideration from the company for the purpose of granting or giving the personal guarantee to the banker. So hence the GST Council has given taken into consideration the RBI circular in this regard, and hence provided these provisions where there is no supply, or it will be treated as a zero in case there is no consideration. Now, when it comes to the corporate guarantee, they wanted to insert sub-rule 2 in Rule 28 to provide the taxable value of supply of corporate guarantee provided between related party as 1% of the amount of guarantee offered, or actual consideration, whichever is higher. In most of the cases, we don't see any consideration. Only when third party is giving, there will be a consideration. Otherwise, we often come across no considerations when undertaken between related parties. So to clarify through the circular that after the insertion of the said sub-rule, the value of such supply of the services to services of corporate guarantee provided between related parties would be governed by the proposed sub-rule of Rule 28, as enunciated in the previous point, irrespective of whether full ITC is available to the recipient of service or not. Now here I would like to draw attention that whatever the circular is there, which I referred in the previous slide, now that becomes redundant in the light of this, because they have specifically called out that whether full ITC is available to the recipient or not, this value needs to be adopted. This is the pictorial representation. In case if the personal guarantee given by the director, if there is no consideration, there is no GST on the transaction. If there is a consideration charged by the director as per the exceptions of the RBI circular, then in that case, GST at the rate of 18% on the considerations would be charged. Now, if the corporate guarantee is given by the parent entity or the subsidiary, that is related party, in case where there is no consideration, as per the GST Council's recommendations, GST will be at the rate of 18% on 1% of the guarantee amount. In case if there is a consideration, then it has to be, both the things has to be compared. That is 1% of the guarantee amount or actual consideration, whichever is higher will be subjected to tax. Now to conclude on that, normally we come across corporate guarantee, and it is a common business transactions that is happening between related party. The important aspect to be noted here is that it is for the mutual benefit for the parent entity and the subsidiary company. Normally, no consideration is charged. So therefore, there is no consideration in this transaction. But however, based on the 52nd Council meeting, the valuation rule has been introduced and it will kick in, which needs to be followed irrespective of whether full ITC is available to the recipient of service or not. Based on these recommendations, the circular number 199, with regard to the parent entity, where there is no invoice which is being issued, and where they have where the subsidiary company can claim full ITC, we cannot use these provisions to our advantage. So now there will be a levy on the corporate guarantee, and we will not be able to take the help of the circular in case of corporate guarantee given by the parent entity. With this, I conclude these presentations.
Thank you, Viresh.
Thank you, sir.
Any questions by anyone before?
Viresh, in the first slide, you said that 126 or 127 of the Contract Act, there is a reference with this corporate guarantee. Can you just explain
Yes.
that?
Yeah. Are you able to see the screen?
Yes, yes. Hello.
Yes, ma'am.
Here we are reading this consideration as anything done or any promise made for the benefit of the principal debtor may be a sufficient consideration. So here the definition is defined in Contract Act. So are we referring the how it is connected with this what we are reading with the consideration as defined under GST Act actually?
So as far as this consideration is concerned, this is under the Contract Act, but under the service tax or under the GST law, there is no consideration per se in the respective act, that is under the service tax or under the GST law. So therefore, under the service tax, the chargeability has failed. So this consideration and the consideration under the service tax is totally different. This is only for the contract. But the chargeability under service tax and GST is different. So I would like to draw differences between contract law and service tax and GST law.
Yeah, when we talk about directors, I fail to understand whether it will satisfy supply definition in the course or furtherance of business. Because director, when he is giving guarantee in his personal capacity, we cannot connote that as he is giving that guarantee in the course of furtherance of business, etc.
What is the definition of business you're using, Ganesh? What is the definition you're using? Profit motive, recurring, regularity, frequency, consistency. Are you using any of those things? Obviously, you're not using those things because 217 does not permit you to use such a definition. Correct. If you are not using the definition in 217, then what other definition are you using to deny that the partner, the director is not doing business? Any other definition outside the statute you cannot use. So therefore, there is no discussion on this. Correct now?
Yes, sir.
Ashton.
Sir, when it is done with an obligation, I'm not looking at the consideration as a point. I'm not saying that there is a consideration paid to the director. Most of the times it's not paid. There is no benefit, there is no activity done with a motive to make gains. Could that not be?
No, definition of business, you see.
Yeah.
Definition, you see.
Got it. Viresh, I have put 2 points in the chat. What do you feel? One is the placement of the new rule. Of course, it hasn't come, so I don't know.
So 1 minute, sir. I'll just.
So basically, if the new rule, sub-rule 2, if it comes before the proviso in the Rule 28, will the position change? Because we have to follow the chronological order. So logically, the proviso should be after the sub rule 2. Is that my understanding correct?
Sir, I would like to draw your attention to just 1 minute, sir. I'll open the presentation. See, where they are going to give the clarification that it is irrespective of whether the credit is full credit is available or not. So therefore, it has to be given effect before proviso itself, sir. Because which has been made very clear in the recommendations. Just 1 minute, sir. I'm trying to open.
Right. Jatin sir, is that understanding correct? The placement of the sub rule should be before
we don't know where it will come. We don't know where it will come.
Definitely we don't know, but I'm just making a thinking that if it comes after the proviso, then again will it be subject to litigation? Because we cannot enforce saying that I will have to follow this.
Definitely
If no
it will be subject to limit. See, let us see now. Let us see this whole thing. Viresh put up the slide saying section 127 says consideration to the surety is flowing from the lender and not from the borrower subsidiary company. Viresh, second, third slide hogappa. Consideration is flowing from the surety, flowing to the surety from the lender. The lender agreeing to lend money to a worthless subsidiary is the consideration for the surety. Okay, Venu?
Yes, sir.
Now you see, why will the surety lend give the guarantee? Question number 1. Question number 2, if the borrower is such a worthless fellow, why will the lender give money? Second question. Third question. If the lender will lend money knowing fully well that he does not have to exhaust remedies against the borrower, but directly invoke the guarantee to recover any dues, can we say that the borrower is really the borrower or the surety is the real borrower? If you answer these 3 questions in all sincerity, we will come to know that this circular is going to be totally wrong. Secondly, not all guarantee contracts will be executed in the same fashion. There can be 100 different ways in which guarantee contracts are entered into. Venugopal will pitch for a project in Chennai. Now, let's say Venugopal is going to award a project in Chennai. The chartered accountant in Chennai who is going to take up the stock audit work for Venu in Chennai asks me, Jatin, I will do the work. What if Venugopal does not pay the fees? So I will tell the chartered accountant in Chennai, don't worry, I will give guarantee that Venugopal is a very decent person. He will not do such hanky-panky things, provided you do your project satisfactorily as per the agreed terms. Now Venugopal will come and ask me, Jatin, you're referring so-and-so chartered accountant in Chennai to do my stock audit work. You know, it is time-sensitive work. If I give him the work and he goofs up the work, then I can't put somebody else to do the work. I will suffer a loss of 5 lakh rupees. I will tell Venugopal saying that, no, he's a very competent person. He cannot afford to mess up your work because it will mess up so many other projects that he is working with me. I will be guaranteed that he will do the work. See, these are all non-contractual assurances. You understand?
Right, yeah.
Consideration is what is directly, immediately, and on the face of it paid to secure consent of each other. Consideration is not something that can be imputed. Anything imputed is not called consideration, it's called motivation. Why you became chartered accountant is not consideration. It is motivation. Some indirect benefit, satisfaction, many of those things. So we have to differentiate when we talk about consideration as motivation versus consideration. Why parent company will stand guarantee? The answer is not that there is consideration, there is only motivation. Motivation cannot be subject to GST. Consideration only can be subject to GST. So I will stop here. Let you please comment on these points to say, can we have one provision that answers entire valuation of GST on corporate guarantee? And that too, when there is no consideration, it has to be a transaction between related persons or distinct persons, isn't it? So therefore,
Yeah.
how does it fit? How can there be a solution in Rule 28 that is the cure for all diseases in Section 7? If we debate valuation, that means we have admitted supply.
Correct.
But we have to conclude whether there is supply in every case. Every time corporate guarantee is given, there may be a benefit to the subsidiary. Benefits enjoyed by subsidiary is the subject matter of tax, or corporate guarantee given by parent company is subject matter of tax. Has to be examined.
Got it.
So please comment on this. What do you feel? Is it possible for, we'll take 3 questions for everyone to please share their views, maybe. Will all types of corporate guarantees, will there be only one type of corporate guarantee contract universally? First question. Or will there be a multiplicity of corporate guarantee contracts? Second, can we identify motivation and consideration and not mix the two every time we're discussing corporate guarantee? Third question may be, is it possible for anyone to be in the business of giving corporate guarantees? Somebody with very large land bank starts only corporate guarantee business. Anybody wants project, he'll give guarantee, he'll take a fee. Business of corporate guarantee. Someone who's got idle assets, wants to leverage it and make business out of it. Can we therefore say that it is only such of those contracts which are involving the business of corporate guarantee giving for a consideration, not being motivation, which only comes within the operation of this council resolution, and not every instance where guarantees are. I'll pause here. When sir, over to you, sir.
Sir, I am now thinking a different issue that will come up, or I don't know whether that will be outside the ambit of it. Guarantees given for performance contracts, like which you said. Generally, for the when there is a foreign and Indian subsidiaries, chances of them giving the counter collateral guarantee saying that okay, that entity will execute the contract. And in fact, recently it happened for in a Indian holding and subsidiary company when the subsidiary company entered a contract with Reliance. So holding company been asked, because Reliance was already been there. So holding company was said that in the event of the failure by subsidiary company, holding company will continue and execute the contract. So it was a tri-party agreement. So I am like further after your discussion. So these guarantees cannot be from the levy is what I am thinking. I don't know.
Sir, of course you're right. See, every time we come across the word guarantee, we must not abandon thinking and say that this whatever circular they're going to issue, whatever rule they're going to introduce is going to be final and decisive.
Right.
Every contract needs to be examined whether it is whether this contract is discussed in that rule. Secondly, the example which you gave is a pre-agreed substitution of contractor.
Correct.
That means if a subsidiary company does not do the contract, parent company has to step in and finish the contract. Can we say it's a guarantee? It's not a guarantee. It's an assurance that in the event of non-performance by subsidiary, the parent company will now become the contractor. It's a pre-agreed novation of contract. That's all.
Correct.
It may have an inherent component of assurance to the customer. Every time assurance is given to a customer does not itself become guarantee. If Venugopal is appointed as the technical consultant for some GST project, there is a natural assurance to the customer that not only will the team do good work, but when Venu is supervising, of course, there is a guarantee. I don't even have to break my head because he is inherently a very disciplined person. He will keep timelines, he will plan it, he will execute it properly. In case there are any deviations, he will notify in advance. See, these are all inherent assurances that flows from reputation. We cannot split the parts and tax them separately when we're buying the whole. So these clauses in contracts will always be there, and department is going to go after everybody with this rule, stating that yes, you have to do valuation. Existence of a valuation mechanism does not abandon the discussion on taxability. So all of us, we need to answer those three questions in the beginning and then come to a conclusion. Which subset of transactions come within the mischief of this valuation provision, and which is the rest of the universe of guarantee arrangements that is still not taxable?
Right, correct.
So we have to go back to Viresh's slides. Viresh, 127, consideration flows to the lender. Correct, no? The recipient is defined in 293 as one who receives the consideration. The lender and the surety are never related persons. Lender and surety are never related persons. They will be unrelated persons. Now I'll give another perspective. Please consider it. How do we know the borrower is the borrower? See, in the loan agreement, subsidiary is named as the borrower. In accounts and auditing, we know that the substance of the transaction must be given effect. Now, how do we decide in substance who is the borrower? Viresh, these questions are for you, my dear. I would like you to please answer. In substance, who is the borrower? How do we come to the conclusion? Who I gave the money, that is the receiver of the money. Can we say that is the sole criteria to decide who is the borrower? Or the assurance of repayment comes from whom? That person is the real borrower. Viresh, hey sir. Log out, huh?
Viresh, you're on mute.
Hello, sir. So sorry, sir.
Viresh, sir.
Yeah.
Yes. Sir, with the limited knowledge, with regard to the...
Elrigu limited knowledge, don't worry, yargo jaasti gottilla. Only 6 years elro. Munde keli.
Sir, initially when the transaction is being recorded by the borrower, for borrowing the amount from the banker, he is the real borrower in the initial transaction, sir. But as far as the...
See, what you say, what you what journal entry you pass is decided based on the transaction. Journal entry is the tail, transaction is the dog. Okay, so don't let the definition of borrower be decided by journal entry. Journal entry should be decided after finding out who is the borrower.
Okay, sir. Sir, you mean to say that the borrower's inability to, honor the debt at a future date, sir?
I'm not saying borrower's inability to honor the debt. I'm only saying, how do you decide who is the borrower? Is it based on the one who received the money in the first instance? Or is it based on the one against whom the claim of the lender exists? I'll give an example. We'll go to one shop near your house. All right.
Yes, sir.
You also don't have money. I also don't have money. We will buy something to eat, and then the shopkeeper looks at you. He says, "Give me money." I don't have money. The shopkeeper looks at you. Oh, sir, ನಿಮ್ಮ friend. Okay, right. And he will give credit.
Okay,
Now,
sir.
who is the creditor? Viresh or Jatin?
Sir,
The shopkeeper says, "ನನಗೆ ಯಾರು ತಿಂದ್ರು ಗೊತ್ತಿಲ್ಲಪ್ಪ." Yeah, the one who I'm going to claim the money from, that person is important. See, I'll give you an example. In Ind AS 116 regarding lease accounting, what they say is the lessor who is the lawful owner of the asset must account the asset at historical cost. The lessee who is the effective user of the asset, he also should account the asset, but not at historical cost, but NPV of future cash lease rentals. So in accounts, we are looking at the substance of the transaction. What is the substance of the transaction in the shopkeeper example? Shopkeeper will write it in Viresh's account. Viresh has one small account in that shop. He will say, "Sir, your friend our biscuit tindrala, nee kodbeka adಕ್ಕೆ 50 ರೂಪಾಯಿ." You understand?
yes, sir. Yes, sir.
So now we have to take these real life experiences all of us will be having and bring it into play in the present situation. What is the present situation? Who is the borrower? The one who received the payment, is he the borrower? I'll give two other examples. EMI, a housing loan directly dispersed by LIC Housing Finance to builder. Can we say builder is the borrower?
No, sir.
But payment went directly to builder. So you have to examine what was the arrangement between builder, borrower, and house purchaser to decide who is the borrower. Correct, no? EMI,
Yes.
monthly EMI deducted from salary by employer and paid to LIC Housing Finance. Can we say the employer is the borrower because employer is repaying the loan to the housing finance company?
No, sir. It is employee who is repaying the loan.
Therefore, the actual cash flow pattern is not going to dictate the nature of existing relationships.
Okay,
All right.
sir.
The relationship is first, then you examine the color of the payments. Now, let us say during your bachelor days, you are contributing some money to the family expenses. You are giving, let us say, 5,000 rupees to your father. Every month, out of your salary, 5,000 rupees you are paying your father. Now, your father does not become Airbnb, service apartment owner.
Okay,
Although all of us have treated home like a lodge only, the relationship is first, color of
yes, sir.
payment is next. So now if you keep all these real life examples, disbursement by the lender, whoever the surety tells, lender will disperse. If he says you go put this money in a startup, the lender will, how lenders give money to Baiju? You just go
Okay.
put it there and guarantee Mugitala. So therefore, in substance, many times surety is the borrower.
Okay, sir.
Surety is the borrower. There is some other investment agreement between the surety and the subsidiary, which is not being considered in all these rules and discussions that is going on. There, everything is not one flavor ice cream. There are 31 different flavors of ice cream in corporate guarantee, but there's only one rule.
Yes, sir.
Again, I will stop. Comments. ಏನಪ್ಪ ಎಲ್ಲ silent.
Sir,
ಹೇಳಿ ಸರ್, ಹೇಳಿ ಸರ್.
sir.
Yes, sir.
Okay. But the I'm only talking about the financial transactions. Guarantor can never be treated as borrower unless the borrower defaults. Though it might be a truth.
No, no, no,
The
no, no, no.
subsidiary is hopeless.
No. See, the guarantor can see when the subsidiary defaults. When subsidiary defaults, guarantor has to pay the money
Correct.
to the lender, but subsidiary need not default for the lender to directly go after the guarantor. See, there's a difference between warranty and guarantee. We studied this in CA Foundation, no?
Correct.
Warranty is default is necessary to invoke remedy. In guarantee, default is not necessary. Whichever is easy, lender can take action. So this is a very fundamental difference we have to understand. In guarantee, default by principal obligor is not a prerequisite. Otherwise, all sureties should say, first you go ask that fellow. Like today in 2A, 3B, what we are saying, you first go ask the supplier, what action you have taken against supplier. Till you finish all your remedies against supplier, don't come to me. You understand?
Yeah.
16(2)(c) is not guarantee contract. So guarantee is not on default, sir.
It is joint and several, right, sir? Guarantor
Huh?
and the borrower. Joint and several liability.
What?
It is a joint and several liability between guarantor and the borrower.
So see, inter se it may be joint and several, but qua the lender, joint and several is irrelevant. The lender can say, I will exclusively take my action against the surety first. Because once the surety settles the debt to the lender, surety steps into the shoes of the lender qua the borrower. And all the
Correct.
remedies that the lender had, he will now have against the borrower. When so I stopped you at that point of default, please continue from that point, sir.
I'm just thinking, sir, because now
Everything is getting
the
upset.
alternative remedies should be exhausted first before touching the guarantor. Because I remember.
No, that's not true. That is not true in contract law. The guarantor is not permitted to take the defense that the lender has not exhausted pre-existing remedies against borrower. That is the fundamental of guarantee law.
It is the volition of the borrower to proceed
Volition of
against
the lender.
whomsoever. Lender,
Volition of
sorry.
the lender.
Lender. Yeah.
Correct.
Yeah.
So I am even saying that your books of accounts are wrong. Venu,
I am thinking, sir.
no, I am saying in section 34 of evidence law, books of accounts are not reliable source of evidence. I am saying books of accounts, I'm auditor, sir, Gube, audit barala. He has simply seen the title in the agreement. And he has called this person borrower, that person lender, nothing doing. It is the surety who is the principal obligor. If you look at rights and remedies, see, how do we look at risks and rewards which we look at to decide whether there is a revenue can be recognized or not, 7, 9, etc. We have to look at that here also. How can we use it only for 7 and 9 but not in guarantee contracts? I will say accounts are wrong.
Okay.
So therefore, this is not a transaction that should be subject to tax like this.
Sir, there are cases also where the companies are recording provisional entry, notional income following Ind AS 109 and Ind AS 115. They say that this is a notional entry and this particular notional income, what they record in the financial statements, is not subjected to income tax. So these are the practical cases. In such cases, sir,
So now what should happen is auditors need to read GST properly to study the terms of the lending arrangement. See, I'll give a small example. When the borrower will actually be the borrower. Borrower is undertaking a project. That project has been appraised. Based on sectoral lending objectives of the lender, the project entity has been approved as the borrower. You understand?
yes, sir.
As a additional, so there is a project entity which is the borrower. The project entity has sufficient assets to secure the debt. They are themselves appraised and decided to be eligible. Over and above that, personal guarantee of director, guarantee of parent company, etc. are taken up, and we have to see the nature of the language in guarantee. I'll give you another example. Many times, project entities give back-to-back guarantee to the guarantor. You understand? L&T takes up a contract to construct a metro project, then L&T will subcontract it to NCC. But the guarantee to NHAI is given by L&T. This side L&T will give guarantee to NHAI. Other side NCC will give one more guarantee back to L&T.
Yes, sir.
So when you, in the conspectus of all the attendant facts, if you bring it, L&T is risk-free. Once L&T is risk-free, where is any consideration? Where is any valuation? We cannot take a slice of the transaction and subject it to GST and ignore the rest of the pie. The entire transaction has to be seen holistically, and there are many judgments to say that isolation of a transaction cannot meet the requirements of law.
So now the new provisions which are being considered, two things. Though, firstly, we need to applicable to only lending contracts, or even there we need to bring distinctions. I'm now little confused.
No, we have to find plain vanilla guarantee arrangements. Plain vanilla guarantee arrangements where securitization of idle assets is the business of the guarantor and the borrower is not appraised. Borrower is not appraised for the credit, and the entire credit sits on the basis of this security. If you look at all the, I feel there are 9 out of 10 arrangements, only one comes within the operation of this provision which they're talking about.
Got it. But very difficult since the circular is silent. Justifying with the officer and everything will be challenging now, sir.
No, I agree with you. I agree with you. Practically, what we should do, take two situations. Like Circular 105, what if in 2 years' time, this new circular also will go?
199 will definitely go.
199 is one thing, but this new corporate guarantee also something will come out through a circular referring to these rules.
Right.
What if that circular goes?
But
See,
if
many
they're
provisions,
amending the rules, no, sir.
but many provisions are going to, now you see, if directors giving guarantee
Hmm.
is an obligation and not and has no consideration, how is it any different for a company giving guarantee if it is really an obligation and not for consideration? It has to be a supply for consideration. If you can show that a director is collecting is doing it for consideration, then GST will still apply, notwithstanding the rule. If a company is doing it as an obligation, then also it will not be liable to GST. All this 1% business will go away. So we have to examine these aspects. The second part is, if we don't want litigation, pay tax. See, this statement is true for everything in GST.
Right.
On foreign exchange fluctuation, should I pay GST? If you don't want litigation, pay tax. On exports, should I pay GST? If you don't want litigation, pay GST. Pay GST to avoid litigation is a universal truth.
Got it.
Pay 28% better instead of 18, then totally no risk.
Hmm.
So if we say, if we are not in this risk averse position, saying that yakappa talenovu, then every corporate guarantee arrangement needs to be examined in the credit worthiness of the project entity,
Hmm.
purpose of guarantee, recourse to surety other than that of a lender. These aspects have to be examined to come to conclusion holistically whether at all there is any risk assumed by the surety. And that should not be for a motivation, but should be for a consideration.
Right.
But sir, in case of group companies, parent company giving a guarantee to its subsidiary, it is because of the motivation, not for consideration.
No, I'm not saying it's this always, but many times it is this.
So my question is, Schedule 1, would it fall under Schedule 1? Because there is no whisper of consideration at all in this transaction.
So now there must be a supply. Supply consideration, absence of consideration is eclipsed by Schedule 1, but all other requirements must be there. Because every benefit enjoyed by every distinct person does not automatically become supply.
So eclipse of consideration, do you mean there is no consideration at all involved in the transaction? Because the way I read, if there is a consideration, if the transaction is not between related parties, just because it is between related parties, the consideration is not charged by the parent company to the subsidiary for giving this guarantee. In that case, I think it will fall under Schedule 1.
No,
Because
my dear.
yeah.
All I'm saying, sorry, please finish.
Here the pure motive is to promote, to support, the business of subsidiary, and it's a motivation. Like a CA exam, you say quoted, becoming a CA is a motivation. Similar way, as similar connotation can be applied here. It is only because of the motivation the guarantee is given to the in favor of the subsidiary, and there is no consideration.
It's not necessarily only motivation. It's not necessarily only motivation. Sometimes there may be consideration also. All I'm saying regarding Schedule 1 is that all other requirements of Section 9 must be satisfied. Only consideration, if it is missing, Schedule 1 will fulfill that deficit. But if it is not even a supply, there cannot be artificial supply imagined by Schedule 1. Schedule 1 does not create father and mother. Schedule, father should be there, mother should be there, baby must be there, everybody must be there. Schedule 1 is giving it a name, supply. By fiction. By fulfilling only one of the missing ingredients, even if that ingredient is not there, it will be called supply. Because today in GST, what's happening? Simply in the air, they are imagining supply. Like, what is that? Holding share service. holding company holding shares in the subsidiary, they are treating it as a service of holding shares.
Hmm.
What is it, Annapurna?
Depreciation also they are treating it as a separate.
So schedule 1 is not a self-fulfilling entry. Schedule 1 is a deficit fulfilling entry. There must be a deficit, and that part of deficit it is fulfilling, which should be nothing more than consideration only being deficit. Venu sir, your concluding remarks, Viresh, concluding remarks, sir.
So just one last question. The 1% value of the guarantee is assumed as consideration, assumed as valuation for the purpose of taxation in the proposed proposal what they have.
Right.
I'm not sure why. How that 1% from where is it coming? What is the?
It is all arbitrary. If you don't say 1%, they'll say it's like 1/3 abatement. See, but the trouble with this 1/3 is, I'll tell you what. The way, when will we go to the rules? We'll go to the rules via 15.4. For this rule 28, they cannot use 15.5. So it is not like the same as 1/3 abatement. So you will go to 15.4 only if you don't satisfy 15.1. You charge 5 lakh rupees. Once you charge 5 lakh rupees as consideration, 15.1 has to apply. Unless it can be shown that it is not the sole consideration, side business you're doing something else. You understand? I can sell at a loss also in GST. So related parties will go into Rule 28.
Correct.
So once you go into rules, whatever they say,
Yeah.
1% is what they are saying. You can give more than 1%.
Sir, with these proposed changes,
Hmm.
look at the arbitrariness of the assessment, sir. Why I think now normally the guarantee will be spread over 4 to 5 years. Now every year they will levy tax at the rate of 1%, and that too on the value of the corporate guarantee. And what will be the place of supply when the subsidiary has registration in multiple states?
Absolutely perfect, bang on.
And supplier, who will be the supplier? Whether my distinct branch, which is located in another state, will also qualify as a supplier in this case, even if he has a registration in such a state, is again the question, sir.
Absolutely correct. So
and whether this will qualify as a continuous supply of service to levy the tax throughout these 4 to 5 years is another issue, sir.
Very true, very true, very true.
Yeah, but will it be continuous?
We don't know. I mean, what will be the proposed amendment to Rule 28? We should wait and see.
If anyone wants to pay tax, what I will do is 1% over 5 years. No, 1/60 I will pay tax every month.
Very clever.
Otherwise, it will become 1% every year, every quarter, every month. If you say 100 crore guarantee is given, 1% is the value. Every month there is a guarantee given. They may say 1% for the whole term. We have to be very careful how we accept this if we are at all we are going to pay tax. And I don't think guarantee is a continuous supply. It should be a one-time supply. Once marriage, rest of life married person.
Sir, what about the guarantees issued pre-GST? It cannot be taxed today?
Because it is like joint development agreement we've signed before a GST.
Yes, sir. So that means the taxable event is the date when we execute corporate guarantee.
ಇದೆಲ್ಲ ಕೇಸ್ ಲಾ ಬರುತ್ತಪ್ಪ.
Sir, ಹಿಂದಿದ್ದು ಪೇ ಮಾಡಿರೋ ಟ್ಯಾಕ್ಸ್?
You already paid tax. Take ITC.
Yeah, during the DRC 03 ಮುಖಾಂತರ ಪೇ ಮಾಡಿದ್ದ.
ಅಪ್ಪಪ್ಪ ರೀಫಂಡ್ ಫೈಲ್ ಮಾಡಿ ಸರ್ ಬೇಗ.
Done, sir. Any questions to anyone? We'll move to the second topic. Okay. Thank you, Viresh.
Yes, sir.
And
Thank you,
please
Jitin, sir.
update the points and share it. I'll share to the group.
Yes, sir.
Nice,
Yeah.
nice
Thank you, sir.
presentation, Viresh.
Thank you, sir.
Vinay?
Yes, sir.
Yeah. Can you
I'll
share?
share the screen. Is it visible, sir?
Yes.
Okay. Good morning, everyone. So the topic for today's discussion was the ITC eligibility on leasehold improvements that we undertake on any leasehold land or any leasehold building. So, before we start, I thought it's relevant for us to go through these two sub clauses of 17(5), which have a restriction on these construction related activities. That is 17(5)(c) and 17(5)(d). It reads that works contract service and supplied for a construction of an immovable property other than plant and machinery, except where it is for an input service or a further supply. D talks about the goods, services, or both received by a taxable person for construction of an immovable property other than plant and machinery on his own account when such goods, services are used in the course or furtherance of business. Now, they have explained that the term construction will include reconstruction, renovation, additions, alterations, repairs to the extent of capitalization to the said immovable property. At the end of this section, there is an explanation which defines what is plant and machinery. It means an apparatus, equipment, machinery which is fixed to earth by foundation or structural support that are used for making outward supply of goods or services or both, and include such as structural or foundation support, but excludes land, building, and other civil structure, telecommunication towers, and pipelines laid outside the factory. So, as can be seen here, what is the ITC restriction that is placed is on construction of an immovable property. But when that immovable property becomes a plant and machinery, then the ITC is allowed. So it becomes relevant to understand what is an immovable property and when something is called as an immovable property. So as we all know, there is no definition of an immovable property under this GST law. So relying on the other acts, so immovable property is defined under clause 326 of the General Clauses Act, which means it shall include land, benefits to arise out of land, and things that are things attached to earth or permanently fastened to anything attached to the earth. Now, this term attached to the earth is again defined in Section 3 of the Transfer of Property Act, which means anything that is rooted in the earth, as in the case of trees or shrubs, embedded in the earth, as in the case of walls or buildings, and anything attached to what is so embedded for permanent beneficial enjoyment of that to which it is attached. So here, as we can understand, so immovable property means something which is attached to the earth, or that is something which is embedded on the earth. It can also include things that are attached to the building or the land for having the beneficial enjoyment of the building or the land per se. So these are the things which could help us in identifying whether a particular goods or something becomes an immovable property in nature. So as we all know, there are many cases under the erstwhile excise law which state that a particular good was not taxable under excise law because it became an immovable property. In many of those cases, reliance was placed on the two definitions that I just read out, that is under the General Clauses Act and the TOPA. Two interesting cases which I thought was relevant for our discussion. One is Triveni Engineering and Indus Limited versus CCE 2000, where it said whether an article is permanently fastened to anything attached to the earth requires determination of both the intentions as well as the factum of fastening to anything attached to the earth, and this has to be ascertained from the facts and circumstances of each case. So here, what was said was, it is important that we understand why a particular thing was attached to the earth. So that determines whether it is an immovable property in nature or not, and that has to be established from the facts and circumstances. continuing that in CCE and versus solid and correct engineering works, there again, the mode of annexation and object of annexation has been said that it has to be given due importance. It further said, the courts in this country have applied the test whether the annexation is with the object of permanent beneficial enjoyment of land or building. Attachment, in order to qualify the expression attached to the earth, must be for the beneficial attachment of that to which it is attached. So here what they dealt was the this leg of the attached to the earth, wherein they said, if I attach some particular machine to the earth, if the benefit of such attachment is for enjoying the land or the building per se, then it becomes an immovable property. But if the attachment is with an intention of enjoying the benefit of the machine that I'm attaching, then it is not, and it would not be covered under attached to earth, and it would not be an immovable property. So deciphering this, can we as a rule say, how do I identify an immovable property? First, I have to check whether it is permanently embedded. That is, nothing less than demolition calls for its removal. So, for example, the walls of a building or any factory walls have to be embedded on the earth, and without me demolishing that, I cannot remove that property. So here it is permanently embedded on the earth. So that would be called under removable property. However, if a machine is attached to the earth or fastened to the earth for a wobble-free movement, then it is not that the plant and machinery becomes immovable. Rather, it is only attached for using the equipment, which is wobble-free and which is fit for usage. Then the purpose of annexation is relevant. Now, whether the annexation is for permanent beneficial enjoyment of the goods, as I was saying, what is relevant is we have to understand when a particular goods are attached, or when something is attached to the building or the land, whether it is for the beneficial enjoyment of the building or the land, or is it for the beneficial enjoyment of the asset that is, or the goods that are placed on the building or the land. So if it is the beneficial enjoyment of the goods, then it cannot be an immovable property. If it is beneficial enjoyment of land or building, then certainly it is an immovable property. There are certain allied factors that can also be considered in determining whether it's an immovable property.
Vinay, can you give examples of all these things which you're saying? Please give examples, otherwise it will become very abstract. Nobody will pay attention.
Okay, so permanently embedded, as I said, a building or a factory wall, that unless and until I put it on the earth, there is, how do I say? It is permanently embedded on the earth for using that. There is no other.
Example one word example kodi. Without example, everything is theory.
Okay, so a permanently embedded could be a factory building or a constructed building, sir.
Vinay.
Sir.
Slum is a building or not? Hut. Made up of coconut fronds. Is it a building or not? Slum. It will fly away in the wind. Is it a building or not? See, please don't subcontract thinking to central excise case law. Triveni engineering, solid and correct engineering, etc. are central excise case law. Because in central excise, the motivation was to make everything immovable to avoid GST. In GST, the very same arguments will come and bite us in the bums. Because if it is immovable property, 17.5 C and D will attract. The very same arguments used for 50 years in central excise will be abandoned in GST. So please don't subcontract the jurisprudence to central excise case law, because they are disadvantageous in GST.
Okay.
So now tell me, slum, hut, is it immovable property or not?
It won't be so because I can easily remove it and
No. So therefore, you should not use those tests.
okay.
When transfer property access building a dwelling unit is a
Mhm.
immovable property, it is not the manner of affixation or the purpose of affixation. If I don't have a hut, I will have to sleep in the site. If I have a hut, then I will not be sleeping in the site.
Okay.
There's a difference here. So therefore, we have to examine rights flowing from transfer of property law and not arguments that were found with some success in central excise. Central excise is full of contradictory judgments.
Okay.
Depending on who argued, when they argued, cases have been won, cases have been lost. So please be very careful if you use central excise case law. Please use transfer of property case law to understand it properly. A cinema tent, this traveling circus. You're aware of it? You're too young to know in traveling circus.
I've just heard of it, sir. I've not seen.
Where Lulu Mall is located in Bangalore, it used to be a very big ground where they would come and pitch a tent. Jumbo circus. They will come and install a tent for 3 months during Dasara season, and there will be all sorts of acrobatics inside the tent.
Okay.
Now, is that tent immovable property?
No.
All this annexation test, object test, all that will all go out of the window.
Correct.
So please explain the theory with examples. Otherwise, your theory nobody will accept. Because this, you understand?
Understood, sir.
Please.
So the thing is, all the subsequent slides are based on this principle. So
then we have to have a pause.
correct. So can I do it again if possible? I'll rethink, as you said, from a different perspective, not from this angle. I will definitely get back and then do another presentation for another day.
Yes, sir. I think we should pause because looking at all scenarios is very important. That's what I feel.
I'll give a few pointers. Please be very careful. I keep telling this repeatedly. We have outsourced thinking to case law. That is the character of a chartered accountant. We don't need brains only. We just need some storage device. Compile all case law, sort them, index them, and keep vomiting them every time we get something, as if to shut people up from debating further. Please don't do that.
Okay.
And in fact, don't even use case law. Give your own theory. What will happen? It will be wrong. That's all. No, at least it is your wrong answer instead of somebody else's right answer.
Sure, sir.
And we have GST law specifically uses words that are not used in central excise law. They could have easily used words from central excise and central sales tax if they wanted to borrow the jurisprudence. They have deliberately not used those words. That deliberateness should be given full force when we're interpreting GST law.
Okay, sir.
So you read, you interpret, or all of us should read, interpret, come to our own wrong answers. And incidentally, if we find a case law, refer to it. If you don't find case law, don't bother about it.
Sure,
there is no compulsion that every sentence should be backed up by a case law.
Sure, sir. Okay.
So please remember hut, slum, and traveling circus.
Got it, sir.
When you're imagining immovable property.
Got it, sir.
Sir, including the temporary sheds which are built in the factories where they raise the height, which are all definitely removable, easily removable, dismantled, reassemblable.
No, so this removal test, destruction test, easily removable, all that is central excise principles.
Correct.
So we should not use those principles. Somebody puts up a site camp, just for people to stay there, work there, etc.
Yeah.
What is the purpose of putting up that site camp? Is it put there permanently, or is it put there as a shelter from rain and sun so that people can do their work? So we have to examine, is it a means of production or is it the situs of production.
In fact, most of the road works, we will find all these big tank containers adjacent to the road, which will keep moving when the work is done.
Prefabricated buildings, as it is called,
Yeah.
20-foot, 40-foot containers are modified to act as portable office, residential quarter, toilets. All these things are being done there. So therefore, we can't use these tests. It worked as inter-excise. Now it is biting us in GST.
Yeah, but in the absence of no new theory, shouldn't we go with the theory, sir?
Now, if we rely on the old theory and it is debunked, saying that no, this is all center excise, it will not work in GST, then where are you? You have to have a new theory now. So we have to come out with new ideas for 17.5 C and D. And let us take example, a cricket stadium and the seating area, the pavilion, is it immovable property? See, these are all questions we have to answer. We only think office, shop, house. Those are all oversimplified examples. After all, what is the pavilion? It is nothing but a seating gallery.
Right.
Then there is an enclosure with air conditioning. Then on top of it, they have fixed a light, floodlights. Is the building to fix the light, or is the light pillar used as a building? See, these are all aspects we have to go into to decide 17.5 C and D. 17.5 C and D is not such a simple question that we will treat it as a well-settled legal position by looking at some irrelevant judgments. We have given up ITC, therefore we think it is well settled. I don't think it is well settled. And those who, I'm telling you, there are already people in many states who have taken building ITC and they're arguing it is not building. In Bangalore, we don't have these cases because most are IT companies. Or we are in renting business, real estate. So in our mind, somehow, mysteriously, the question of immovable property seems to be very clear.
Correct.
What if you're constructing a factory, you install the machinery and then put what is called a housing to enclose the machinery. Now, is that a building? Normally, you will put up the building, then you put machinery inside the building. Here, you install the machinery, then you cover it with a lid. Now, is that building or a housing, as it's called? See, these are all questions that will come up from Pune, Chennai. Bangalore is busy with Rule 18 and 4A, 4B, 4D. ETO by TTO. FIRC received, not received. See, we are all starving for cases because our cases are all garbage cases. Refund 9610,000 cases we are having.
Correct.
ROTEP refund exempt, if exempt is Rule 42 applicable, not very children ಕೆಲಸ ಮಾಡ್ತಾ ಇದೀವಿ ನಾವು. Is my humble submission for you to please consider. Widen your horizon. Think about more things. We have better English than rest of country, better PowerPoint skills, but subject illa.
Sir, 17.5 C and D equally applies to both leasehold as well as freehold properties, right?
True.
Okay. Even if the lease is for a very short period.
I'll give you an example. There is a factory land of 100 acres. Okay, 100 acres factory land, 100 crores per year. Lease rental is being paid. 18 crores GST is paid on the factory land lease rental. Now, this 18 crores GST, Vinay, ninige the question now.
Yes, sir.
18 crores I want to take ITC. Department is saying, no. The land lease is service for constructing factory building on this 100 acres. So you understand?
Got it.
But we want to take 118 crores GST. There is an advance moving also from Hyderabad to say that land lease is not for is not admissible as credit because it is hit by 17.5 C and D.
Correct, sir.
So the stand being taken is my factory shed is only 1 acre. So 1 acre land lease is for accommodating the building. 99 acres is for storage of material open to sky. Therefore, lease of land for other than constructing factory building is admissible, and credit taken of 90% of the 18 crores. So 17.5 C and D is not settled position.
Understood.
Including the windmill is now treated as immovable property.
Because specifically they provide.
Now they haven't provided for solar,
Right.
but now the department is putting in the same line of windmill to the solar system.
No, I know. See, what if a windmill is set up under a operating lease model instead of a sale of power?
Right.
So credit is admissible. It's all about innovative contract writing and financial engineering. In the past, people have drafted contracts. See, joint development agreement was invented by somebody. It was never there in any act. Finally, it got accepted. So like this, all this land building, etc., new contracts are going to be invented. Only we have stopped innovating because we think it is settled position. Vinay,
Yes, sir. Yes, sir.
my dear, you need to come out with examples
Sure, sir.
to disprove the theory. Maximum it will be scary for all of us, but in 10 years from now, maybe that will be the norm in GST. Vinay's ideas.
Understood, sir. Again, I'm really sorry for this. I'll get back to you.
Yak sorry, don't be sorry.
No, because the entire presentation, sir.
Illapa, you have been taught wrong. That stop thinking when there is central excess case law.
Okay.
That is what study group is for, to tell all of you that if you have been taught wrong, not anymore.
Got it, sir. Understood.
You have been taught wrong, we have also been taught wrong. That's why you should be told
Sure,
to
sir.
pause now and do version 2.0.
Sure, sir. Sure. Thank you, sir.
Sorry.
Yeah.
Yes, sir. Good, sir.
Sir, I have a basic doubt, sir.
You, madam, okay, go ahead.
Okay. No, sir. Like when we are into compliance, like we don't have any other choice but to rely on the judgments because we are not lawyers. So we cannot make any persuasive
that is
arguments.
not a guarantee.
Correct, no,
madam,
sir.
being lawyer is not a guarantee of anything, madam. It's okay, leave it.
So like when we are into, like, unlike lawyers, we cannot make some new jurisprudence and then make, oh, this is what the theory, this is what my persuasive argument. We cannot do that, no, sir. So we have no choice but to take shelter under some decided case laws.
No, even then you have no guarantee of outcome. Still, you will get notice.
Notice is fine. So the reason why we are going behind that is that because of like our own, professional limitation.
No. I don't think there is any limitation for a chartered accountant, and only except those we inflict upon ourselves.
Okay.
And we are doing compliance does not mean we are prohibited from claiming credit and contesting it. If the client is willing to contest, if the client is not willing to contest, no lawyer can compel his client to contest. So there is no disqualification for you or me, madam. We are not under any sort of a disqualification, limitation, handicap. It is what we come under for various reasons. So I don't accept that there is any limitation. And consequently, there is no prohibition from innovating. Cholungo.
No, sir. Thank you, sir.
No. See, we should not, youngsters should not make, I am doing 1 and 3B, so therefore I am barred from thinking. No. That is not.
Where do I put forward my thoughts, sir? Like, I cannot tell you to
madam, I'm telling you. You take ITC. Sai Prasad is there to fight.
Okay. So we have to form a new theory, new jurisprudence, take it to the lawyer and then fight it. That's what you mean to say. Like,
No. I'm only saying, please question the past jurisprudence of its relevance and validity in the present. We can't hide behind the outdated case law.
That I understand, sir.
Got it.
Thank you, sir.
All right.
Thank you very much, sir.
Thank you,
Rajesh,
sir.
sir, anything to add? Okay.
Sir, mute.
I think first and foremost thing, I completely endorse whatever Jatin sir did mention. In fact, nowadays when we are replying, we are mostly trying to look for a case law first and then try to reply without even trying to understand the facts. And also we are seeing that many of us are trying to get the standard replies available in the net, because now the issues are getting standardized. The replies also are available in the net. They say you can use that. And I come across when the matters come for appellate stage, the replies will be totally devoid of the facts of that particular case, and many factual things would have been missed out while replying. So the application of mind to the facts of the case, understanding the facts and the issues which are being framed, as we first understand, and then having found your solution, then look for a case laws to support those your line of argument, rather than first start from a case laws or already ready-made replies available on the net and trying to use that to file a reply. I think that is where we are missing out, as I feel. Jatin sir, what do you say? This is what I am coming across in majority of the cases.
Good point, sir. Good point, sir.
Because reply ಎಲ್ಲಾನು ಈಗ net ಅಲ್ಲಿ ಸಿಗುತ್ತೆ, standard replies. 2A 3B difference, there is a standard 30 pages or 20 pages or 15 pages reply. So 16:4 standard reply. So they can look at it but not simply adopt it by without looking to the facts of the present case. That's what I want to just highlight to the members.
ಯಾವ ಸೈಟ್ ಸರ್ ಅದು?
google.com.
ಹುಡುಕ್ತಾ ಇದೀನಿ, ಏನೇನೋ ಬರ್ತಾ ಇದೆ.
ಸರ್ ಚಾಟ್ ಜಿಪಿಟಿ ಅಲ್ಲೂ ಬರ್ತಾ ಇದೆ ಸರ್.
ಹೌದಾ? ನೋಡು.
ಚಾಟ್ ಜಿಪಿಟಿ ನಲ್ಲಿ GST ರಿಪ್ಲೈಸ್ ಬರಲ್ಲ.
ರಿಪ್ಲೈಸ್ ಅಲ್ಲ, ಸಮ್ ಡೈರೆಕ್ಷನ್ಸ್ ಯು ಗೆಟ್ ಸಮ್ ಇನ್ಫಾರ್ಮೇಶನ್ಸ್ ಅದು ಯೂಸ್ ಮಾಡ್ತೇವೆ. ಹೌದು, ಪಂಟರ್ಸ್ ಇದಾರೆ ಅದ್ರಲ್ಲೂ ಈಗ.
Then it will start with we humbly request a good self.
These conveniences and its benefits sometimes create impediment on our thinking. Actually, stop thinking. Just try to look for ready-made solutions.
Okay, thanks, Venu.
Yeah, thank you, sir. Thank you, everyone.
Thank you.
Bye.
Thank you all. Thank you.